types of discovery. So again, these are various tools that we have as lawyers to be able to investigate a case and to obtain information from the other side. To kind of give you an analogy or a comparison to sports, the discovery process is a little bit like if in a football game or other type of sporting event where the coaches exchange rosters for their players. In a true discovery, it would also be the coaches would trade their playbooks with each other. Now, they don't do that in the real world, right? But in law, we as lawyers have to tell the other side who we're going to have as witnesses, so they know ahead of time, and then also what evidence we have. So these are the various methods that we can use to obtain this type of information. So the first method is called a subpoena. A subpoena is an order that is issued by either a judge, or it could be from a grand jury in a criminal case, or it could be from a lawyer that's involved in the lawsuit. And a subpoena is basically a demand, an order that is provided to somebody to show up and testify as a witness at either a deposition, an arbitration, or a trial. And so if I want to have a witness appear, I will have a subpoena issued. I will write up a subpoena. I will then have it served upon the person, typically by a sheriff's deputy, and then they have to appear, and if they don't appear to testify, a judge can hold them in contempt of court and actually incarcerate them for criminal contempt. So one type of a subpoena is to make somebody show up and testify as a witness. So subpoena power exists with a judge, a grand jury, a lawyer. Legislative bodies sometimes have subpoena power, like Congress, and that's the power to compel someone to show up and testify. Now there's also what's called a subpoena ducis tecum, right here, which you guys will never remember, and don't worry about that, I won't test you on that. That's a subpoena for documents, a records subpoena. And I tell you that for the real world. I've had a number of students over the years that have worked at banks or worked for accountants or a medical facility, and they had nothing to do with the lawsuit. You know, you're working at the bank and you get a subpoena, ducis tecum, from a lawyer in a divorce case, let's say. Really common. And so the subpoena is for the checking account records for one of the parties in the lawsuit. So it's like a divorce case. I would subpoena every bank and ask for 2 years worth of bank statements so I can see what the money flows are. Now the bank, they don't need to appear, they just need to provide those records. So what they will do is they will send me photocopies of the statements with an affidavit saying that these are true and correct, and then I can use those in court as evidence. Or maybe from a hospital to obtain medical and treatment records, x-rays, radiographical studies. Or maybe I need police reports, so I'll subpoena the police department to obtain the police reports. Or bank or tax records, I'll subpoena the accountant to give me tax returns that, you know, like past 3 years or something. So you can have both, a subpoena to appear as a witness along with records. So that would be both. For like a doctor, for example, I might subpoena a doctor to appear and testify at trial and to bring with all medical records, okay? Number two. Oh, okay, so a subpoena is issued to a third party typically. So a non-participant in the lawsuit, like a bank or a hospital, okay? Number two, interrogatories. Interrogatories are basically a written question and answer that the lawyers exchange with each other. So if you're the lawyer representing the other side, I can send you written questions, usually 20 or so. There's a limit depending on what state you're in. And your client has to provide a written answer to each of my questions. And their answer is made under oath, so if they lie, it's perjury or false swearing, depending on what state you're in. Also, anything that's set forth in the written answer is considered an admission and can be used in court. So I could write an interrogatory to the insurance company, and in the interrogatory I could put something like, please state in detail how you believed Anthony Caruso died. And they would have to write me back a paragraph explaining why they think he committed suicide. And if they don't respond, I can have a judge order them to respond. It's called a motion to compel. So an interrogatory is a written question with a written answer that the lawyers give to each other for their clients to respond to. So that's why I have L to L, lawyer to lawyer, question and answer. Now, we don't use interrogatories in Oregon state courts. We do in federal court. But California, they're used extensively. And again, this is where if you are, maybe an employee for a company, you're not really have nothing to do with the lawsuit. You're not being sued, but you may have to assist in preparing, help the lawyer write up the answer to the interrogatory, because you may be the one that has that knowledge. I will tell you, they're very stressful writing those things. I hate writing answers, because you got to look at every single word, because every single word is considered an admission. And if you admit something in that interrogatory, maybe you didn't have all the information available, you may have lost the whole lawsuit in that one answer. So you got to be very careful about that. All right, next we have an RFP, which stands for Request for Production of Evidence. So again, this is lawyer to lawyer. These are very common. In fact, almost every case these will occur. And this is basically a list of information, documents, or any other type of evidence. Could be blood tests, urinalysis, it could be polygraph, it could be videotapes, it could be security camera footage, bank records, financial, life insurance, car top, whatever. Any information that the other lawyer has, that their client has, or their company, I can ask for if it's relevant to the case. And so I will send a list of all the documents and other type of evidence that I want to the lawyer. They will then typically have 30 days to respond to provide me with that information, copies of the documents and that kind of thing. I mean, I had a case once where we received a request for production. I was defending the company, this trucking case. And they requested to be able to inspect the semi-truck that was involved in the accident. Well, at the time, the semi-truck was back in Connecticut. So we literally had to drive it back here to Oregon to respond, to allow the plaintiff's lawyer the ability to go look at the truck, inspect it. We actually met at the rest stop up by Wilsonville, by the golf course up there. And they inspected the vehicle and all that kind of thing. So it can be, I mean, literally it was a semi-truck that we had to provide. I've had other cases where literally the number of documents filled a 53-foot semi-truck trailer. That many, I don't know how many, hundreds of thousands of pages. It was a huge bankruptcy case. I mean, huge. The photocopy fees alone were like $25,000 just to copy everything. It was crazy. And that was back in the 90s. You don't even know what it'd be now. Now everything's digitized, right? But back then we used paper. So request for production of evidence, lawyer to lawyer. Next we have request for admission. This is similar to an interrogatory, but they're more narrow in scope. And this is basically lawyer to lawyer again, where I would send a request to the other lawyer to have their client admit or deny a certain fact. So for example, I would write to the insurance company lawyer, admit or deny whether or not Anthony Caruso is dead. They would write back, we admit that he is dead. We deny that he died accidentally, something like that. So by doing that, I can tailor down very specific points of fact and require the other side to admit or deny it. They're very targeted. And the reason why you do that is so whether you know what evidence you need or don't need to provide during a trial. So the reason why I asked them if he died, if you remember, they denied that paragraph that said he was dead. And the reason why they denied it, because they had the word accidental in it. So I would then go through and do a request for admission, admit or deny that he died on July 20th, admit or deny whether or not he is dead. Very targeted. That way I don't have to prove the date he died, I don't have to prove that he is in fact dead, I just have to prove whether he died accidentally or not, which is going to be hard enough. But. And finally we have depositions. These are very common. A deposition is a question and answer that's live. Or nowadays we do it by Zoom. And so basically this gives the lawyer an opportunity to ask a potential witness, the other side, employees or parties that the other lawyer has, or people that are not involved in the lawsuit other than they were a witness maybe to an automobile accident. So this gives us the opportunity to interview them ahead of time before trial, to ask them any relevant question. Their answers are under oath, so if they lie, it's perjury. And all the questions and all the answers are written down by a court reporter, and then they're published so we can look at the printed words. We typically videotape them as well nowadays. And so these are very common. And again, in the real world, this is where you, even if you're not being sued yourself, you may have to appear at a deposition. If you're an employee of a company, like in human resources, it's really common. You might have to come in and answer questions about the background of the employee that was hired, and the training, and all that kind of stuff. So a deposition is basically the same type of questions you would ask in a trial, all written down ahead of time. That way, you know ahead of time, before you ever go to trial, what the witness is going to say. And if they say something different in trial, you can pull out the deposition and basically read it to the jury and the judge and say, okay, you remember the deposition, you remember you were under oath, and at that time I asked you what color was the car, and you said red. I asked that same question today, and you said the car was green. So were you lying then, or are you lying now? Either way you were lying, right? Or either way you're not credible. So that's how we use depositions, that kind of thing. Now, a deposition can either be lawyer to lawyer. In other words, I'm going to depose your client and you're going to depose my client. Or it could be a third party. Again, like a bystander that witnessed an accident, or a human resources manager, or a doctor that did the treatment at the emergency room, or whatever the case may be. So that could be anybody that has any relevant information to a case. All right, so I will ask you on the midterm for fill-in-the-blank question, list 4 types of discovery methods, anything on this page. And then I also may ask you which method, and I've highlighted in green the 3 primary ones that we use in the real world. And so I might ask you a question like, which discovery method allows a lawyer to interview a witness live and ask questions under oath before the trial? And the answer would be a deposition. Or which form of discovery will allow a lawyer to obtain records from a bank by issuing an order, a subpoena? So it'll be one of those 3, okay? Now, what happens if you send out a subpoena, maybe to a bank, or I send a request for production of evidence to the other lawyer, and they don't respond? They sandbag me. They drag their feet. Or maybe I don't hear anything. I mean, this has happened to me many times. I send a subpoena to a big giant bank, and I never hear anything back. I send another one, and I send a nasty letter, and another strongly, sternly worded letter, right? Well, eventually, you get fed up, so I'm going to file a motion to compel. And that's a motion that you file with the court, and basically show the judge, I've issued a subpoena 3 times, nobody's responded, and so the judge will then order I mean, literally the CEO of Wells Fargo to come in and say, how come you didn't respond? And you've got 2 days to get this information over, or we're going to fine you, or potentially even jail. So a motion to compel is when the other side is not responding, or a third party is not responding to your discovery. You can have a court have a hearing on it, and then, I mean, that makes the judge mad. Judges don't like to hear that. And then ask for monetary sanctions. If you're out-of-pocket expenses, you can ask for your expenses to be reimbursed and that kind of thing. I will tell you, it's fairly common. It's a lot more common in family law, like divorce cases. I think every motion to compel I've ever had to file was in a divorce, because their side wasn't giving me the information. All right. Oh, I forgot to talk to you about the word motion. So we have these various different words. I keep saying motion. Motion not in sports, like the receiver goes in motion. A motion is when you're asking a judge to do something, okay? So there are hundreds of motions. So we talked about a motion to dismiss. That's when I'm asking a judge to dismiss a lawsuit. Or a motion to compel. That's when I'm asking a judge to order somebody to turn over documents. But we can have there are motions for all sorts of things. Maybe I want the jury to be able to go out to the scene of an accident in an automobile car crash case. It's called a jury view. So a motion for a jury view. Or maybe I don't want the witnesses to be sitting in court during the trial because I don't want them to hear what other witnesses are saying. So I'll file a motion to recuse the witnesses, and they have to sit outside in the hallway, or even a separate room. Or it could be a motion to exclude evidence. Maybe the other side is presenting a videotape that's been altered, and so I'll file a motion to suppress the videotape. So anytime you're asking a judge to do something, I mean, even a lunch break, if I get hungry in the middle of a trial, Your Honor, I move for a noon lunch recess, so we can go eat lunch. Anytime you're asking a judge to do something, you have to do it by motion. Motions can be written, or they can be verbal in court when you stand up and you object. Hearsay, Your Honor, that's hearsay, I object. That's a form of a motion. So whenever you see that word motion, that's when a lawyer is asking a judge to do something of some type. All right. So next, after we have discovery, there may be additional pleadings that need to be done at that time because you've learned additional information. So maybe you found out there's a third party that needs to be brought in. So maybe you do a counterclaim or something at that point. And then eventually the discovery process will be concluded and the case will be then set for a trial. So that's the next step. Complaint, answer, discovery, trial. So I'm going to break there for today because I've only got a few minutes left. And that's where we'll pick up next class at the trial process, and we'll go from there. So,